Well, good morning, everyone, and welcome. We're at the top of the hour, so we're going to get started as we have a lot to go over today. We're going to try our best to stay within the allotted time frame. We've all got busy days, hopefully, and we want to make sure that we have the time to address everyone's questions. Colleen West is pleased to bring you today's webinar hosted by Outlook HR featuring Hudock Employment Law Group. Before I introduce our speakers and tell you a little bit about Colony West, here's a few housekeeping items. Today's webinar is being recorded, and a copy of the recording will be forwarded to everyone who registered for the event, along with a copy of the presentation. Be on the lookout for that in the next day or so, and if you have any questions throughout the session, please make sure to use the chat box. We're going to do our best to address all of your questions during and at the end of the presentation. And I just would like to acknowledge everybody that is in attendance of this. In my 25 plus years of working with hundreds of businesses, I've found that those that invest in the knowledge, acumen with regards to the risk management of their business, they tend to have more profitable businesses and reduced operating costs. So my hat's off to everybody that's investing their time in becoming a better employer. Now for the main event. For those of you who are new to Colony West, we're a full service advisor providing solutions for insurance, payroll, HR, and safety. Our diverse risk management platform allows us to understand and partner with our customers in a truly complete way. And I welcome you all to contact us to discuss your company's labor, risk management, and insurance needs after this event. As I mentioned, Outlook HR is hosting today's webinar. The team at Outlook HR has partnered with Colony West in providing customized and innovative solutions to workforce management, including payroll, HR, and safety. And I'm pleased to present Evelyn Blanco of Outlook HR this morning. Evelyn has over 20 years of experience in human resource management and is certified by SHRM, Society for Human Resource Management. Additionally, we're very honored and pleased to have on our esteemed panelist from the Hudock Employment Law Group, Mr. Robert Hudock. Robert has over 2 decades of experience as an attorney with over 10 years dedicated specifically to representing employers in employment law matters. Colony West has received much positive feedback from the many customers Robert has helped out, and we thank him for that. Now I'm going to hand it off to you, Evelyn.
Thank you, Bill. Thank you, everybody, for joining us this morning. Your time is valuable, and we appreciate your attendance. We will be covering new laws that will be effective 2021 and a few that have passed this year. We know that COVID has been challenging for all of us, and we will touch on some subjects, but we will be focusing mostly on new laws. So again, we appreciate your attendance. And Robert, the floor is yours.
Thanks so much, Evelyn. Good morning, everyone. As Bill mentioned, we have just 1 short hour to cover a lot of material, so I'm going to get straight at it. I thought that it would be a good idea to introduce the program with talking about, we always title these presentations, these are the laws, the new laws that affect employment. And so I wanted to cover very briefly what we're talking about when we say laws. And essentially that breaks down into 2 categories. And that is statutory law, or, regulations and ordinances, and case law. When we talk about, and one thing first, we have also California law and federal law. Now, technically, both California and federal employment law apply to all employers and all employees in California. As a practical matter, however, we only see almost exclusively application of California law. And the reason that is because when you have a employer and an employee who are subject to both, the application is the one that's most favorable, or either the practical effect or the rule regarding it is that you apply the one that's more favorable. And so if you have a plaintiff's attorney who's filing a lawsuit on behalf of the employee, they're going to do that. They're going to file that under California law because that is clearly more favorable over federal law, and a lot of reasons. And also there's crossover coverage. And so now let's talk about statutory law. If we talk about the statutory law that we deal with in California, for the reason I just mentioned, we're talking about the the Labor Code, which is the main statutory law that we deal with. And just for information, I have there that the federal law with respect to that, or the counterpart, is the Fair Labor Standards Act. When we talk about harassment, discrimination, and retaliation, those types of things, those are all covered in California by the Fair Employment and Housing Act. And then I listed on the presentation the different federal laws that are the counterpart. There's also regulations, and the regulations provide information regarding interpreting and implementing the statutes. And so in California, we have the California Code of Regulations, federal counterpart being the Code of Federal Regulations. And then the other thing we have, and a lot of you are familiar with this, is, and this is a relatively new phenomenon, and that's the local ordinances. So for example, we have all the different minimum wage and sick leave requirements that apply in, say, Santa Monica or Los Angeles, and that type of thing. And then very briefly, with respect to case law, what we're talking about is Court of Appeal and California Supreme Court case law. And so the things that happen in the trial court, number one, you don't usually know about because it's not anything that's published. And number two, it doesn't have any precedential effect. And that's why it's only when it gets to the Court of Appeal and they publish opinions that we deal with the cases, like the cases I'll be talking about today. And so let's move on to the statutes. And as has been mentioned, we're not going to focus today on the COVID statutes that, at least as of today, are set to conclude or not apply after December 31st, which is just in a few weeks. I suspect that it will be extended, but as of today, we don't have information confirming that it will.
Robert,
there are, however...
I'm sorry, Robert, to interrupt you. So just to confirm, so when you say the statutes that are set to expire on the 31st, we're talking about the sick leave, the COVID sick leave that they'll be calling it, and then the extended FMLA, all of that, correct?
Yes, that's the Federal Coronavirus Response Act is the federal law that we're talking about. And an example of a state counterpart is in September, the governor signed off on supplemental paid sick leave to what it saw as filling gaps in the FFCRA. And those are the ones that are at least currently scheduled to expire as of December 31st. There are, however, at least a couple of COVID-related statutes that explicitly are going to apply after December 31st. And I've listed these on the presentation. I'm briefly going to talk about those. And as you'll see on the slide, both of these are currently scheduled to be effective until January 1st, 2023. And the two that we're just going to briefly mention today are the Cal OSHA enforcement and employer reporting requirements and the workers' compensation presumption, which has been already in effect, but it's going to, at least as stated right now, be in effect until January 1st, 2023. As far as the Cal OSHA enforcement and reporting requirements are concerned, what we're talking about there is with respect to the enforcement, we're talking about that they're given enhanced enforcement capabilities, specifically with respect to the pandemic. And we've listed there on the presentation the two categories of enhanced enforcement that they're going to have. And it's just talking about, they can do inspections and issue orders to shut down entire work sites or workplaces. And they also have the authority to issue citations for serious violations. There are also some notice requirements that apply when there is a known COVID case or cases. And there is also some notice requirements that apply when you have what's considered an outbreak within a workplace. And there is a specific definition to outbreak, but we do have a lot to cover today, so we're not going to cover that here in our presentation. Now, the one that'll be more frequently applicable, I guess I'll say, is the workers' compensation presumption. And essentially what that says is that with any COVID case, if there's any employee who has who is test positive for COVID, the presumption is going to be, at least for purposes of workers' comp benefits, the presumption is going to be that it's work related. And what the effect of that is that the employee who tests positive can get essentially paid time off for that COVID, even if they don't have any supplemental paid sick leave left over, or they are in an industry that doesn't, or which is an exception to the supplemental paid sick leave. Again, there's a lot that goes into the workers' comp presumption, but we want to get through all the material, or as much of the material as we can today. So I'm not going to spend much time on that. But in terms of the what's going to be, or what's new and what's going to remain in effect, we have the, just a moment.
Let me, Robert, we have a couple of questions.
Yes.
We have, in reference to what we were speaking about with the FFCRA, do health workers qualify for FFCRA?
For FFCRA, that's a good question, because when the law was instituted, and the Department of Labor, that's the federal agency that handles employment issues, had specifically an exemption that applied to healthcare workers and emergency responders.
Right.
Now, what that was at the time was it gave employers of quote unquote healthcare workers and emergency responders the discretion to exempt people from the expanded sick leave and the enhanced emergency family leave. As of September, the DOL redefined healthcare worker. And it narrowed pretty significantly who can be considered a healthcare worker for purposes, at least of the federal law. And essentially what the DOL did is they said only, it's very complicated. The definition is extremely complicated, but essentially it's people who, I'll say, actually provide healthcare, as opposed to, for example, in the previous definition, it was basically anybody that worked for an organization that provided healthcare. So that's pretty significantly narrowed the people who qualified as healthcare workers. In addition to that, in September, California enacted its supplemental paid sick leave law. And when I talked before about a gap filler. So one of the main reasons for the California supplemental paid sick leave law was to provide paid sick leave to those healthcare workers that did not fit within the definition of healthcare worker under the old DOL definition. And so now that you have the different definition of healthcare worker, and you also have the California paid sick leave, and again, it gets very complicated, but what the healthcare employer is left with is a decision to apply the federal law and or not exercise its discretion to eliminate those people who are still healthcare workers from coverage, or work with the California law and operate under the procedures and requirements that apply to each. Again, I wish I could talk about the nuances of that and the ins and outs of that, but we just don't have time today.
So just so I understand, are you saying that it's basically up to the employer whether they use the definition of a healthcare worker?
I'm glad you asked that, because what it is a decision between whether or not to decide whether you're going to I don't know if I can explain it completely, but it's about whether or not you have previously exempted people, and whether or not you want to take the position that the federal law, you used the federal law before, and you either exercised the exemption or you operated pursuant to the requirements that are under federal law previously.
Got it. Okay. Then the second question we have, I believe it's referencing SB 1159, where the question is from Deborah Johnson. It says, is it 14 days for positive test or from where symptoms start?
I have something on that, and I don't want to misstate. Test positive.
Positive test. Okay, wonderful. Thank you. Thank you. All right, should we move on to the next slide?
Yes. Why don't we?
Okay.
All right. So very quickly, with respect to the other statutes that are going into, well, not very quickly with respect to one, and I'll tell you why. We will talk quickly about the others that are going into effect as of January 1st, 2021. The topic of AB 5, this is the statute that talks about the independent contractor versus employee and implementation, codifying the ABC test that was announced in the Dynamics case. That's a whole day's worth of discussion in and of itself, and maybe some of you are already very familiar with that. The change that's happening in January 21 is there's going to be some industries that are specifically included in the exception from AB 5. And there's also some information regarding business to business service providing. We have listed on the presentation those industries that are getting added to the exception, and then to state it generally, the changes that they're making to the business to business provision of services. It revises as it states right there, it revises the conditions under which B2B providers are exempt. And they also extended that to sole proprietors. The important thing to remember is when we talk about an exception to AB 5, we're not saying that, okay, the people who meet the exceptions don't have the burden of proof to prove that they're an independent contractor, or that they can automatically designate them as independent contractors. What we're talking about is they are exempt from AB 5 and therefore exempt from the ABC test, but they still, so then what you're dealing with when you talk about designating someone as a independent contractor, it is what's called the Borrello test. And basically that's a multi-factor test that is set forth in some California case law that talks about 13 different things that you can look at to make that decision. You know, the right to control, whether or not they're in their own business, and things like that. Then a couple of more not as important and kind of very narrow application statutes is, for example, the AB 2143, and with that one, there was a statute that went into effect in 2020 where it established that, because prior to 2020 you could, and it was pretty regular, that whenever there was a settlement, you'd put into the settlement agreement an agreement by the usually former employee that they will not apply to be rehired, they'll not seek to be rehired, they will not get rehired, and so forth. There was a law that was enacted in 2020 that generally permitted that. There was a few exceptions. They've added an exception in 2021, which is for criminal conduct. With respect to those that have criminal conduct, there can still be no rehire provisions in a settlement agreement. And there was already existing in the 2020 law, for example, an exception for people who have found to have engaged in sexual harassment or other similar activity. The next more narrow subject is and this is SB 1384, or no, excuse me, SB 973. What?
Sorry, Robert. We're getting a question from Jennifer Grady, as in, can you define what a consultant is?
A consultant for purposes of what? Because they can have it can have a slightly different definition.
I think that she's referring to AB 5.
Oh, and the new exception for consulting services.
Right.
No. And what happens with that is they will announce the exception to the statute, and the statute will simply say, and this is with respect to any statute, they will announce something like, they'll say, okay, consulting services. And then what you're left to do as someone who is subject to it is do your best to define what consulting services is until you have some case law that interprets it, or some other authority that interprets it. A lot of what's been going on with the COVID laws is, and I don't know if this will continue with respect to other laws, is that you'll have these FAQs and guidance documents that come out where the relevant authorities will give that definition. Like I said, I don't know if that will apply with respect to non-COVID statutes, but if it doesn't, let's say, and it's by the normal process, you have the statute announced, you have certain terms within the statute which are vague, at least somewhat, and then the folks that are subject to it or it applies to, they do their best to say to define what consulting services are, and I realize that it's difficult for someone who's it applies to order their behavior, but this is how it works. And then it's not until you have a court of appeal case or some direction from some other authority that provides that definition and interpretation.
More guidance. So would it be fair to say, as if I'm an HR professional or just a business owner, just to make sure, then rather just find complying with the ABC test, that they go through all the testing, the Barella test, just to verify that they are in fact an independent contractor? Is that a way to approach it?
Yes, that's exactly right.
Perfect. Thank you.
Yes. We talked about no rehire, SB 973, and this applies to employers only with 100 or more employees. I don't know that we have anyone here today that fits that definition. but there is pay data reporting that's required, and you can look at the statute to determine what those requirements are. Here, this is somewhat the extension of time for the statute of limitations for labor commissioner complaints is not too significant because it doesn't affect those matters that are filed in court. And so pursuant to AB 1947, folks who do file with the labor commissioner are going to have an additional 6 months. It goes from 6 months to 1 year. The labor commissioner has, and then I'm moving on to SB 1384. The labor commissioner has always had the authority to represent people who can't afford a defense or can't afford a lawyer otherwise, to represent them with respect to what are called de novo hearings. That's when you have a labor commissioner, wage and hour labor commissioner decision that you don't agree with, and you appeal it, to the Superior Court. And what you do is you have a trial just like any other trial in Superior Court, and it's called de novo, meaning anew, meaning it doesn't take into consideration whatever the decision was by the labor commissioner. And so the labor commissioner has always had that authority. They're extending this to arbitration. And that can be whether it's with respect to something that's a de novo hearing or any other arbitration matter. There's one about successor liability. We can't get too much into that because you have to analyze what constitutes a successor. But then this is AB 3075. What we have time to discuss today is that this is providing or this is establishing that what a company that does meet the definition of successor can be liable for the wage and hour debts of its predecessor. And so a company that in a purchase, for example, is going to need to look at whether or not the definitions of successor and predecessor are met. And also, I mean, this is what happens in any transaction. You look carefully at what the outstanding liabilities are of that previous company. Here's one that may affect folks, and this is AB 3075. And I want to make sure at the outset that what we're talking about here is judgments, not settlements. And what the new statute says is that if there are any judgments that an employer has with respect to any kind of wage and hour issue, it's about whether there's a violation of the wage order, but that's pretty much any wage and hour claim or violation. There now needs to be a disclosure on the statement of information that you file with the Secretary of State each year that there was that judgment. Then there's one, I'm not going to talk too much about this one. There is a statute with respect to rest breaks for security guards. And the reason for it is there were some cases that came out that were, I'll just say, confusing and not realistically applicable, or it's not realistically implemented by security guard employers. And so this statute was enacted, and this is AB 1512. This statute was enacted in order to hopefully rectify that situation, at least address it, and make it not so confusing and easier for security guard employers to implement or have rest period policies.
We have a question, Robert.
Yes.
When you have a moment. Okay. This is former employee layoff has claimed to have filed complaint with labor commissioner, but layoff was not COVID related. He filed with the EDD claiming it was COVID related. He was not paid COVID sick pay during the 6-day period of missed work due to in-home COVID exposure and pending test result. We didn't realize it was due at the time. We set up the test appointment when notified of exposure. Employee was not paid COVID sick pay for the days missed. Vacation time remaining was used. Recently realized COVID sick pay was due to the employee, and we want to issue payments once we have funds. What are the repercussions for not paying at the time of employment / upon layoff due to that job ending, not COVID related, and now paying the employee the former funds due? So sorry, I know that was quite a bit. So I think what's happened, the employee was laid off, not due to COVID. And, but prior to that, they lost some time due to a COVID exposure, but were not paid the COVID sick leave, and they want to pay it now. So they want to know, what are the repercussions for not paying when he was still employed?
Well, that it's still kind of an involved answer. There are a lot of issues that are implicated by that situation. Let me answer this way, at least for purposes of our presentation. But then if you have, we can feel free to contact Evelyn or contact me to address the nuances of that question. And what I'll say is this: it's always, you're always going to be in a better position if you go ahead and pay it now. The one thing I'll also mention that is applicable in other situations is we have to keep in mind that these statutes were, all these statutes that have come out and all these rules and regulations were developed on the fly. And so it is difficult to impossible for an employer to have been up to date as of the date that it came out, or to completely understand what's happening. So the point of mentioning that is, my sense is that there's going to be some forgiveness with respect to something that's technical and something that's minor. And so that's why I say it's always going to be better. You're going to be in a better position if you pay it. But I'm happy to answer the details of that question offline.
Okay, I received that person's email, and I'll get that to you. But really quickly, so if I receive that question, I would say to my client, I would say, definitely pay what's owed immediately. And I'd also recommend that some of the penalties that would be paid if it was brought to the DOL be paid. Would that be accurate? Or would you just recommend paying what was owed at the time?
I'd say this. I'd say yes is the short answer.
Okay.
And I would say that the obviously the more that you do, the better position you're putting yourself in with respect to not technically following it prospectively.
Got it. So don't delay, pay as soon as possible. That's what I'm hearing.
And again, there's always nuances. It depends what those penalties are. It depends upon the facts of your situation and whether those facts present arguments for, why you didn't comply, or perhaps even why you weren't required to comply. And I don't know if that's the situation here, but I'm just telling you, or I'm demonstrating further, that there are always nuances that you have to look at. Okay.
Okay, thank you so much.
Okay, so now we're at the most important and pretty momentous statute among those that are going into effect on January 1st, 2021. And this is with respect to statutorily protected leave. And one of those is ones that you, even if it's not applicable to your workplace, you probably heard of at least, and that's most people refer to the FMLA, the FEMLA, the federal law that applies to this. But really, in California, what we look at when we have a case regarding this is the California Family Rights Act, which us attorneys refer to as the CAFRA. The only time we look at, or the time that we look at federal, is if there is something that's not covered in the CAFRA, or to interpret terms in the CAFRA. So the laws and regulations regarding FEMLA are still relevant, but it's not that we first look at the CAFRA. But now, with respect to the changes in the, this is with respect to California, the CAFRA, here's what the changes are. And this is the most momentous. Prior to the effectiveness of this statute, the family leave requirements applied only to employers who had 50 employees within a 75-mile radius of the workplace in question, where the person who was seeking leave or didn't get leave or whatever worked. What the new law says is it reduces that number from 50 to 5. And so that's going to, that captures a lot more employers. And it probably captures a lot of the folks who are in attendance today. The other thing that the statute does is it eliminates the 75-mile radius condition. In effect, it's not going to matter that much because anybody who has, a lower number, less than 50 employees probably isn't dealing with a situation where they have multiple workplaces. But with respect to this, all those employers who now will be subject to the requirement to provide leave have to comply with all the requirements and all the procedures that go along with providing family and medical leave. And very quickly, the leave that we're talking about applies, well, let me put it this way. It applies only to people, and when I say these are the employees, it applies only to people who have a healthcare provider designate them as having a quote unquote serious health condition. So
they need medical certification for that, correct?
That certify them, yes. And there are forms, there is a specific CAFRA form that is used that should be provided to whomever or to the employee. And you do need to provide certain forms to them as part of all these rules that are in the family leave laws for their healthcare provider to complete. And just again, to fit this into our presentation, the kinds of requirements that are associated with family leave are the notices that you have to provide, the communication that you have to have, what you can and can't do with respect to the healthcare certification. You have to leave their job open under certain terms. There are defenses, but you have to leave their job open. That's what I'm referring to when I say statutorily protected. And there are return to work requirements and many, many more. I just want to raise those to give you an idea. But as for those folks who do have between 5 and 49 employees, and this is new to them, I highly recommend that you do consultation now with your HR consultants and or your attorneys to get up to speed, at least at a general level, on these requirements, so that when and if compliance with these requirements arises, you are prepared at a basic level to at least do the initial requirements and then get more into the requirements that follow after family leave is requested and granted.
And so wouldn't it be fair to say that not only do they need to follow the requirements for what we in HR call CIFRA, but you call CAFRA, which other leaves can run concurrently, right?
That's always been the case.
Right, but what I'm saying is for small employers, most of these leaves haven't applied to them, or many haven't. And so they not only have to worry about the new things with, I'm just saying that in general, it's quite to use your word, a labyrinth of requirements, not only for this leave, but all of those that may run concurrently.
Yeah, I mean, there's pregnancy leave, for example.
Right.
There's this new parent leave, and so yes, they need to be. So, for example, when you have pregnancy, there's rules as to when the leave applies concurrently or separately.
Right.
In other words,
Exactly.
pregnancy leave provides this many weeks and family leave provides X number of weeks. That may or may not increase the number of weeks that they're entitled to.
Exactly. And that's what I was trying to get at. And before you move on to the new Parent Leave Act, we do have another question. It says, I'm a San Diego employer with employees living in Tijuana or Mexico. Are those employees eligible for the FFCRA? And if they're working in San Diego, wouldn't that be a yes?
Correct. So to put it generally, the application of the FFCRA is based off of the workplace, not the worker.
Okay,
Does that make
thank you.
sense
Yes,
to you, Evelyn?
it does to me. And I think, yes, basically it's where you work, where these, yeah. Okay, thank you
Not where
so
the
much.
employee lives.
Right, it's even,
what they're-
'cause you can be 15 minutes away from San Diego and live in Mexico. We all know that, right? So,
Correct.
okay, thank you, Robert.
With respect to the new Parent Leave Act, I'll just do this very quickly. It's a reduction in the number of employees that an employer can have and still be subject to those requirements in providing that leave. And the other thing is about how previously, when you have two parents that work for the same employer, you only needed to give it together, basically, as there's only one period of leave that applies to both of them, whereas now it applies separately. So you've got the one parent that has their allotment or their right to a certain amount of leave, and the other parent has the same amount of right to that period of leave.
All right. Just to let you know, Robert, we have about 19 minutes. So
yeah, we need to just move on, and we need to pick on the topics.
Okay.
So let's go right on to case law. And like I mentioned before, this is the Court of Appeal decisions that have come out in 2020. And actually, with respect to when they become effective, they're effective as soon as they're published. And some of them are even retroactively effective under certain circumstances. But the subjects that have been covered in California case law in 2020 is what is employment, and what is employment, the whole independent contractor versus employee, certain compensation issues, as you might expect, some various cases with respect to PAGA, and certain other wage and hour issues. And then the rest of them fall into cases regarding harassment, discrimination, and retaliation under the FEHA. Now, very quickly, and I'm going to really go quickly on these. The first case, or the first subject, first of all, is employee versus independent contractor. And this is we've already talked about the general rule with respect to that. This is an application of the federal test, not AB5, but the reason I included it is because it gives an example of how much stronger the requirement is in California, and also an example of where someone in this position would still qualify as an independent contractor. And basically, it was a case that involved, you have doctors who have their own practices, but then have privileges at certain healthcare facilities. What they ultimately came out with in this case was that, given that typical privilege arrangement, the doctor was still an independent contractor and not an employee of the hospital at which he had privileges. Now, and here's the demonstrative point. Under AB5, the result might be different, because let's not forget the B of the ABC test, and that is whether the person who's doing the work is doing the very work that the putative employer is in the business of doing. And so, if you have a court that very strictly applies AB5, they could say, oh, well, the doctor is providing healthcare and the healthcare center is in the business of providing healthcare. So, they don't pass the B part and therefore they're an employee. But there are other factors that would go into that. I just wanted to demonstrate the different application of the federal test. And when you say federal test, you could just as well say the Borello test because it's very similar. So I'm just demonstrating the differences and the higher difficulty it is to pass the ABC test than it is the federal and or Borello test. Next cases, or I think there's more than one case. I'm not going to actually, that's very specific. It talks about that. Well, what I'll say about the next case, and this is the case regarding who is an employer and who is an employee. It was an inmate that was on a work detail program. The important point about that is when you have a volunteer, that person is not an employee, and all the requirements that go along with somebody being an employee don't apply. Big topic that has come up a lot recently is the principle of joint employment. Whether under the circumstances, an employee who's doing work has, in a certain way, more than one employer. So the question is, does he have more than one employer? Does he or she have more than one employer? And if he or she does, are both employers equally responsible for 100% of the things that occur with respect to that person's employment? And the cases that came out this year addressed that. There is a multi-factor test, if you will, that is used when deciding whether one entity is a joint employer or not. But with respect to application of those factors and I'll call it the division of liability between two people who are considered joint employers, we had two cases. One dealt with just the application of the factors and finding that one of the two people alleged to have been in joint employment or joint employers was not a joint employer. The other one that's more important, I think, for our discussion today is situations in which both people are joint employers, but essentially what this case says is the court's going to look at they're going to apply a certain common sense approach, and they're going to look at the facts and circumstances and decide under a certain circumstance if one of those companies, one of those employers wasn't really involved in a certain aspect of the employee's employment, they're not going to hold that the one that wasn't involved in liable for what that specific thing is. Just to give an example, let's say there's sexual harassment in the workplace, and you have two what are considered joint employers. You have the company that's providing a service, and you have a company that's providing payroll services. You have the PEOs, you have these types of things. Or a lot of times it comes up in temporary staffing agencies. If you have a temporary staffing agency that is supplying a worker, and basically they supply the worker and then they do nothing else but pay their wages, that's likely going to be a situation where, sexual harassment happens within the workplace. That's likely going to be one of those situations where a court is not going to find the joint employer liable for anything that relates to the sexual harassment. Let's see. Let's talk briefly about exemptions and the salary test. I'm going to put this very fast. When we talk about an exemption, you have non-exempt versus exempt. When you have an exemption, there are two tests you need to pass. The duties test, where they are the most important factor being discretion and independent judgment. And then you have the salary test. You have to pay them a salary at least 2 times the minimum wage. And a salary has a certain definition. It's a fixed amount that you pay to an employee for the value of their services, not the time they perform their work. And it has to be a regular, you can change salary from time to time, but it otherwise has to be a regular, same payment over some certain period of time. So certain types of compensation don't qualify as salary. And pretty much any incentive compensation isn't going to apply. And the case that came out this year dealt with commission. That's one type of incentive payment. That's not included in salary. And the significance of that is you can't look at the amount of that compensation and deciding whether you meet the salary test of paying 2 times the state minimum wage. The meal and rest period cases are not that momentous. There are 3 cases that came out with respect to that. There's one that talked about rest periods being hours worked. That the nuances of that, or the cases in which that becomes most significant, is commission only paid employees. I won't get into the details of that, but if you do have a commission only compensation system, then talk to your HR consultants, talk to your attorneys about rest periods and keeping track of their time. The second case just confirmed what was already the law, that with respect to most wage and hour cases or claims, there's always the attorney fees that the plaintiff can recover in addition to whatever damages they get. But with respect to meal and rest periods, that's not true.
We have a question, Robert.
Yes.
It says, if the salary is the same each time, why are employers allowed to deduct partial sick/vacation days from them?
Can you read that again?
If the salary is the same each time, which it should be if they're an exempt employee, why are the employers allowed to deduct partial/sick vacation days from them?
There's only very specific circumstances in which you can deduct partial days. But the fixed amount that's being referred to when you talk about the definition of salaries is the fixed amount that is due, otherwise due, if you didn't deduct those partial days, because the situations in which you can deduct partial days are limited. And so since it's allowed for you to deduct, they're not going to hold that if you deduct, it's no longer a salary. But what you have to be careful of is that you are deducting those partial days under the allowed circumstances so that you don't lose the exemption, at least for that pay period.
And so the question that's following up is, what are those exceptions?
That's too involved to get in, especially with the 8 minutes that we have here.
Okay. All right. Thank you.
So let's just move on to travel time. That the general rule again is commute time is not compensable. Time driving between work sites during the workday is compensable. With this one, the rule that is that derived from this, or that it existed before, but this was a specific application. There are certain circumstances where commute time is compensable, and that's where the worker is sufficiently subject to the employer's control during that travel time. The situation here essentially was that the worker had to carry certain tools and parts in their car, and the employer had certain requirements of vehicles with respect to carrying those tools and certain things you needed to do. But what the court found was that that was not sufficiently subject to the control of the employer, because really the thing to look at is, hey, could that worker have somebody else riding in their car? You know, could they do what they wanted to? Could they stop along the way or leave early and go have breakfast? Sure. So they said that that's not sufficiently subject to the control of the employer, so that wasn't compensable. Reporting time pay, that was essentially a case that confirmed the case that came out last year, which was Tilly's. And this had to do with situations in where employers have systems where the worker has to call in 30 minutes before a scheduled shift and find out if they're actually going to be put to work or not. And the court found that that is a situation that calls for reporting time pay. This was just under slightly different circumstances, so the court published it and to give further guidance as to what circumstances, similar circumstances, demand work reporting time pay. Vacation pay. The thing I'll mention here is, again, the general rule is there is no legal requirement to pay vacation pay. It is something that most employers decide to do to remain competitive in the marketplace. If you do, however, provide vacation pay, vacation time, then you're subject to certain rules regarding that vacation time or vacation pay. And just real briefly, it's things like you can't have a use it or lose it policy. Certain time has to carry over to the next year if it's unused, and that can be subject to a cap. And also one of the main ones is, to the extent that an employee has accrued unused vacation at the conclusion of their employment, you have to pay it out because they're considered wages. The one thing that the one case that came out this year, the issue that it arose is a lot of employers are now turning to unlimited, what at least currently is called unlimited vacation policies, where it's kind of subject to the person's discretion. Unlimited doesn't necessarily mean fully unlimited, in that the employer can still have controls by saying, okay, if it gets to a point where it's being abused, then it can be addressed individually. It just can't be a situation where you have pre-announced parameters and there's any accrual and things like that. And that's really all I can get into now, given our 5 minutes.
Great. I'm so sorry. Go
Okay.
on.
Do we want to have minutes for specifically for question time, or do you want me to continue?
I think that we have gotten most of the questions. We've been answering them as they've been coming up, so we're good on that.
Okay.
Let's cover one more case, and then we'll start to wrap up. How about that?
Let me think about which one is most important to address. Just one moment. Just a moment. The ones regarding harassment, discrimination, and retaliation are pretty case specific and apply in certain somewhat narrow situations. And I was actually referring when I discussed the case before about courts looking at whether someone who is deemed a joint employer shares in the liability. That's at the first one about whether they're a joint employer was discussed in that case we were looking at that time. The one regarding who of the two joint employers are going to be liable is a separate case, which is discussed later in the materials.
Given that we only have 3 minutes, Robert, I think we need to wrap up.
Okay.
Okay. First of all, Robert,
so I'll just say this. The other subjects that were covered, as I mentioned, there was harassment, discrimination, and retaliation. Those are pretty case specific. In other words, they looked at the facts of that case and decided whether or not there was harassment, discrimination, or retaliation, or whether they could get past summary judgment and go to a jury. Those kinds of cases provide guidance. That's something that the attorney will look at when you have your certain situations to decide whether or not there are strengths and weaknesses in the case. The other topics covered were rounding. That's when you have a situation where regardless of the time the person punches in, they either get rounded up to the next 15-minute increment or rounded down. What you need to keep in mind, particularly if you have, we have only a couple minutes, so I just want to mention things, some subjects generally. Like I said, there was some PAGA cases, nothing momentous, just kind of applied some of the rules that already exist. There was some cases, there was a case regarding wage orders. You need to know the wage order that you fit in, and because the rules slightly different, are different from wage order to wage order. And we covered most of the wage and hour. There was a case regarding here's one that's maybe important. There was a case regarding what's called the de minimis doctrine. And what that means is, for example, if you have meal periods and the requirement is at least 30 minutes. Let's say you have somebody that's punching out at 28 minutes or 29 minutes. Is that going to be something that is taken into consideration? The answer is, in California, yes. because the de minimis doctrine doesn't apply. And I'll just end there since we're at
Okay.
our 59.
Thank you so much. Thank you, first of all, Robert, for for presenting. It is very much appreciated. Any questions that any of the participants have, Outlook HR is happy to assist, and we have services that we can talk to you about at any time. And my contact information will be available to you when we send out the recording of the webinar along with the PowerPoint presentation. Bill? You're muted.
I am, thank you. The
You're welcome.
adage, you've heard the expression, ignorance is bliss. I thank God I did not watch one of these webinars when I was starting in business, because I never would have. I don't know about everybody else, but that's some terrifying stuff there, and the road ahead just continues to get more complex each year. So best of luck to all of us in navigating this. The information was informative to me, and I'm always surprised that having done this so long that I continue to learn new things from both of you. So thank you very much. We are going to wrap this up. We will, again, as a reminder, be sending a copy of today's presentation to you. If you have any additional questions, please feel free to reach out to Evelyn, Robert, or our office, and we really look forward to seeing you at our, or not seeing you at our next webinar. We'll be emailing details and dates on that shortly. So everybody have a great week and a great rest of the year.
Happy holidays to everybody. Thank you.
Take care, everyone. Thank you.